Welcome back to Settlement Nation and part 2 of our deep dive into the defense perspective with Jason Neville from the Jerry Spence firm and Jakob Norman from Trial Lawyers for Justice. If you missed part 1, make sure you go back and give it a listen, but we are going to jump right back in. So Jason, a lot of people that we come into contact with have only ever practiced on the plaintiff side, and they actually have a lot of negative feelings towards defense attorneys. Given that you and Jakob, as well as some of the greats that we're yet to have on the show, like Nick Rowley and other plaintiff attorneys, started on the defense side, it'd be nice to know more about how defense attorneys look at their cases. Maybe you could just explain a little bit about this, especially with your 19 years on that side, and just give your background and some of the motivations of defense attorneys.
Yeah, sure. I think maybe overall, defense lawyers and plaintiffs lawyers at a very rudimentary level think of their cases as the same. It's financial gain. At the very, very basic level before you get into the bigger motivations for us as trial lawyers. But the way that we go about that financial gain is entirely different. Defense lawyers look at cases as work, and bigger cases mean more depositions and more travel and more motions, which is more billable hours, which is increasing the bottom line and feeding their families. And that can be a big frustration for us on the plaintiff side and as trial lawyers, because what we want to do is get to justice, and we want to get to justice as quickly as possible. And justice is getting money generally for our folks. And so it can be frustrating for us. Now, part of some of that frustration that you talked about is you have what I would call the true believers, and you have quote unquote true believers on the plaintiff side that they've never seen a plaintiff that didn't deserve tens of millions of dollars and never did anything wrong to contribute to their injuries, and are very vocal about that. On the defense side, we have the same, where I can think of somebody I practiced with and against who had a nursing background, and her husband was a physician, and there was never a physician that had ever done anything wrong in his or her life, and would treat every plaintiff and every plaintiff's lawyer as if they are the devil trying to do evil on the good doctors of the world. And that can be tough. And it can be tough because as plaintiff's lawyers, when they're doing these things, not only are they hurting us potentially, financially, which is a small part to pay, a small price to pay, but they're hurting our clients. And that gets personal pretty quick.
Jason, before we go on, I think it's important to know, obviously you started on the defense side and you basically grew up going to your father's work, which was a defense firm. And I started at your firm as well. But I think it's important to know, and whether it's you or me or Nick Rowley or Dan Shar, these other plaintiffs attorneys that started at defense firms, you don't start at a defense firm saying, oh, I have this goal of screwing people over. Oh, I have this goal of paying less than a claim's work, or, oh, I have this goal of somehow joining the member of the dark side. It's not really how that works. And especially for folks coming right out of law school, it's not like law school does a good job of prepping you for the law or really helping you understand the intricacies of the different kinds of practices. And it's also important to know that back in the day when Jason and I were doing this in the early 2000s, we would actually still take plaintiffs' cases when there wasn't a conflict with some of our other work. But you're not, and that happens probably more in small towns than people want to think it does, where some people do things on both sides of the fence. But there's never this commitment right off the get-go to go screw people over. Now, I think over time, sometimes the longer you do stuff, you get into patterns and there's some things that could be said for that. And that's why it's so important to be talking to Jason, who actually spent 19 years doing it before he made a switch. But I think for listeners to know, the fact of the matter is they have a job to do. And as we get into the motivations, it would be nice to say, well, Jason, how would you start working up the file, and how was that looked at from working it up and billing a file? How does that kind of portion work?
Well, and part of it, I and maybe I didn't. I like to think that I looked at things a little bit differently than traditional lawyers did, and a lot of that came from my father. I grew up remember being 6 years old, and all I wanted to do was be a lawyer and live in Jackson Hole. And what that came from was following my dad around in the summers when he would go to depositions and he'd go to hearings and he'd take me along. And he would be against and fighting against some of his best friends. And then one of his best friends was Ed Moriarty, who started the Spence firm with Jerry Spence. And they would go, and sometimes I'd get to watch this, and a lot of times just hear about it. They would fight like crazy and fight like dogs during the day. And then at night, they go to dinner, and they were best friends. And that's changed overall, where, number one, we don't get that interaction between plaintiffs' lawyers and defense lawyers anymore. When we go out and we're flying around the country, you get done with the deposition and you're not necessarily going out to dinner and being cordial. You're going back to your laptop and doing work. And so some of that, I think, has changed the interaction between both sides to where it is more antagonistic now than maybe it was in the past. And with that, it's sort of this dissociative aspect to it, to where you don't see the personal aspect of the other side. You're not having dinner with your opposing counsel, learning about their conversations with their client that aren't protected, of course, but about sitting in their kitchen, crying with them about how they're going to pay their bills. You don't see that. And so what you see is this sort of X's and O's, us against them. And so I think that I'm getting far away from your question, but I think that's what colors a lot of what we see today. But getting back to sort of how I would see work cases up and see things is, it was a very, very rare exception that I saw a case on the defense side where I ultimately concluded that the plaintiff was lying or wasn't hurt or was trying to scam the system. It just, there were a couple times that I saw that, and I tried those cases. But it was very rare. And usually it was, someone is hurt. A lot of times they're hurt really bad. And it's just trying to figure out, did my client do it? Or did they do it, but there's a legal way that I can pursue to defend them so that, I hate to say it, you're defending insurance money or corporate money, that they don't have to pay as much. And so I tried to start it all from a human aspect, and maybe it made me not good at my job, I don't know. But it always was from that human aspect that if somebody was hurt, let's see how we handle it.
Well, Jason, it kind of reminds me, and I think it's important to know, you worked more on the case, but there's a case back at our firm in the day where we really believed the plaintiff was lying about the injuries. And, you can't always put your finger on it. And this, like you said, it rarely happened to where it's a complete lie. And I think you filed a offer of settlement in the amount of $1 and took it to trial. And I think the theory was this was a drunk driver that got injured back when the gear stick used to be on the floor and injured his ribs on the gear shifter, but said he was the passenger and all this stuff was going on. But really the jury ended up believing him. And that was a case that probably should have never been filed. It's not like he went to his plaintiff's attorney and said, I'm going to lie about this all. But from every once in a while, you saw something that was kind of that gross and far right. The rest is really just trying to figure out the actual value. And most of the time as a defense attorney, is it not what you were doing for those 19 years is trying to come up with that kind of reasonable value was, fair value, or honest value was?
Yeah. Oh, for sure. I mean, I always thought that I had, it was not an ethical duty, but it was sort of a moral obligation that I needed to get the insurance company to value the case where I thought it should be valued. And if I did that and it didn't settle, well, then that's okay. Then we can go try the case because, assuming I'm right, then the plaintiff's counsel or the plaintiff, they're valuing it too high. But I always try to, and it was, a lot of times this dental surgery of trying to extract money out of the carrier to try to put it on the case so that it could get settled or resolved in a way that was fair. And the difficulty in doing that for me was this fine line of doing what's right and doing my job, which you have ethical obligations and moral obligations, which sometimes conflict, but also doing it in a way that insurance company and that adjuster is still going to give me work. Because sometimes, and it happened, and I was fired by a couple of different insurance companies because I did the right thing. And you sent them a letter saying, you've got to settle this case and you've got to settle it for this amount. And if not, you're putting your insured at risk for an excess judgment. So I felt that tug of doing the right thing, but also making, my business partner, the insurance company, happy so they would keep feeding me work. And that's tough that's very hard for defense counsel. And it's something that they deal with constantly. And you will see some that do it the right way, what I would say, and others that do it the wrong way and tend to just make the insurance company happy.
Well, let's talk about that. Another kind of struggle that comes out of that with partners and law firms and this whole billable hour thing that, of course, plaintiffs attorneys typically never track their hours until they get a fees award, and then they're trying to put it together backwards. But can you talk a little bit about that kind of all around pressure of billable hours from your firm, your partners, down to the insurance companies that you represent or used to represent?
Well, sure. I mean, it's the lifeblood of any law firm or any defense law firm, because that's the only way that you make money. And there are very few law firms that do not have billable hour requirements. And those requirements are, 1,800 to 2,000 to 2,200 hours a year, which is a lot. Because you can go and you can work a full day and you could be at the office for say 10 hours. And I was horrible at keeping track of my time and billing my time. But there would be so many days that I'd be at the office for a full day, be there for 10 hours. And at the end of the day, you'd look and you'd say, I billed 3.5 hours today. How is that possible? And people who are efficient billers, they're say working 10 hours and billing 6 to 7 hours. And so it's a tremendous amount of work that has to go into billing. And then on top of that, you get the pleasure of every single insurance company that comes in and cuts your time and says, wait a minute, you spent 10 hours writing that huge summary judgment brief? No. We're only going to pay you for 8 hours of that. And they do it all the time.
And, I was at the firm with you. I remember we'd get a report from a major national carrier. Obviously, I won't say who it is. And every once in a while, it would say, hey, you spent 5 hours doing X. A paralegal could have done 3 hours of that. So we're going to pay you at the predetermined paralegal rate for your firm. If you don't like this, you're going to have to basically tell us why you had to do what you do. And for me, the time that I would take not billing to go fight this, audit firm of this national carrier, I would end up giving in, and that adds up and adds up and adds up over time. So you just made me think of that horrible mess of trying to justify why my hours were actually correct when I wasn't even capturing all my hours anyway.
No, Jacob, one of my biggest frustrations with the business side of it was I would make a phone call or I would do work and I would go to put my time down. And the first thought as I'm put into the system and writing out my little justification is they're going to think that I'm lying. They're going to think that I am putting down too much time, and they're going to cut my time. And that would trigger this whole waterfall of what are you doing? Why are you doing this work? You don't like this work. You're just a cog in the wheel. You're not doing any good in the world. And so every, 0.2, which is 12 minutes of time that I would put down, because you had to justify every 6 minutes of your existence. It would remind me of why I hate my job. and you're right. You would bill time and they would cut it, and it would take too much time to go back and justify it. And so you would let it go. And it's horrible when you're trying to do the right thing because all you do is get your time cut. But you have these big firms that do insurance defense work, and they have great strategies for billing time, for capturing all their hours so they can meet those billable hour requirements. And so they're gaming the system. And so this is the wrong term to use, but I'm going to use it anyway. They're cheating the insurance company to try to make more money. And so in order to combat that, the insurance company has to come in and review the time and cut the time in order to try to get it down to what's right. But the people that lose out on that are the people trying to do it honest. Like you and me in my old firm. You're trying to do it in the correct way, in the honest way, but what you're doing is coming up against this huge behemoth that is cutting you down.
In the most interesting part of this, when you think about a system and the way it's set up, and I don't think anything's going to change, but it's not like you're rewarded for good work. You're not paid if you do good work. There's not a different system if the work you do is better, than the defense attorney 5 counties away that covers that area. I mean, it's a system that where being adequate is good enough.
Yeah, precisely right. And that was a big frustration for me is you're not, when you're a trial lawyer and you go out and you do good work and you get a good verdict or a good settlement for your client, well, you get the emotional reward for that, which is huge, right, and fulfilling. But you also get a financial reward for that. On the defense side, if I was able to get a case done early and I was able to save $80,000, $100,000 on defense costs because I got it done early, resolved earlier or resolved with emotion, we'd say. My reward was, okay, move on to the next case. You don't get to take the afternoon off and reward yourself, because if you take the afternoon off and go have drinks with your colleagues to celebrate, the one thing everybody is thinking about is, well, I'm losing a whole bunch of money right now because you're not billing. And it bleeds over to, you can be standing in line at a store and it's taken too long. And the thought that comes in your mind is, well, this is point 2. You're wasting my time here. I should be billing out at $300 an hour, but I have to wait and listen to you for an extra 6 minutes. It's a tough way to make a living as a lawyer.
Well, I want to have you kind of explore that a little bit more, because I remember kind of when we were working together at the end of the year, or maybe depending on the carrier, there's kind of an analysis of, hey, what are the rates? Are we staying with you? And those kind of pressures are additional pressures that are coming in because there are other defense firms ready, willing, and able to and actually aggressively want the work. But can you talk to us a little bit about that that kind of pull where you're trying to keep this person who makes sure you can feed your family while you're doing these cases, and what that pressure is like year after year, just to keep insurance companies as clients?
Oh, sure. I mean, not only are you focused on doing good work, which you need to do well, you need to do adequate work, and your word is perfect, because if you do great work, it doesn't matter. It does not matter to the insurance carrier. I think it matters to some that are, say, medical malpractice carriers, because it's a bigger deal, or if it's a carrier that the insured is a product manufacturer. And so doing good work in those situations means something, but doing great work or good work for run-of-the-mill car accident cases doesn't matter to the carrier. What matters to the carrier is the bottom line. And so that when I use that word, that you're just this cog in the wheel, you're sort of this, no matter how good of work you're doing to some of these carriers, you're just this nameless little widget that's producing for them. And that can be extraordinarily frustrating. And it comes to bear when you would get these invitations to keep doing work that you've done for 10 years. And they would say, okay, we're having a sort of auction, and we're inviting you, my firm in the middle of Wyoming, that does statewide work and has for this carrier for 10 years, sometimes 30 years. And we're inviting this Denver firm, and we're inviting this Salt Lake firm, and you are going to bid on your hourly rate. And we're paying you, let's say they're paying $200 an hour. You can't start at $225 to get an increase, which you haven't gotten an increase in 2 or 3 years. You're going to start below your current hourly rate. And I tell you, that's frustrating. And, I luckily was in a position for most of my career that I could say, well, screw you. I don't need your work. I'll do other people's work. But my firm couldn't do that. And a lot of my partners would say, well, wait a minute, we need to feed all these associates. And so, okay, we're going to look at doing that haircut. And that's tough. And that's just a reality, I think, of business. And these big companies can bully the smaller folks. And it's like, a Walmart coming into to a community and effectively shutting down the small mom and pop stores. When you have carriers that are doing that, they're shutting down the smaller firms that have done work for them forever, good work, and catering to these bigger regional firms that, as we talked about before, can be these big mills.
Well, if that's kind of a little bit of the negative aspect, Jason, and for, again, those people don't know, in efforts to strengthen relationships with carriers, is there dinners? Is there getaways? Is there anything like that going on the other side? Is there whining and dining? Is there some other secret sauce going on that the average plaintiff's attorney may not know about?
Yeah, there's a little bit of that, and they have rules against that, taking gifts and things such as that. Sometimes you'd be out at a mediation, or sometimes you'd have an adjuster attend depositions, and you could try to buy them dinner, and a lot of times they would refuse. What it's turned to is defense firms are part of, I'm trying to do this without naming names, are part of larger national groups, where there'll be a large group. Well, I'll just say it's a group like U.S. Law, which is a great group, okay, and it's catered to defense firms, and it's an international group, and they will have one firm from each state, and the goal of it is to try to bring work together to spread it out amongst the states. So you have a firm in Florida that's a member of this group, and they have clients that do trucking. right? And so you come to these national conferences or these regional conferences, and they'll introduce the Wyoming folks to their clients who do trucking, and hopefully you can then get together and you can kind of share work that way. That's the way that I see that the sort of the marketing goes for defense firms, because it's really hard to market yourself to insurance companies. There's just not that real avenue to do that. Running sort of commercials or website stuff is ineffective. You have to get to the higher ups at the insurance company, and those higher ups are folks that would come to those sort of national organization types of things. It used to be that we could just go out and we would go to an insurance company, say in Denver, where they would have an arm, and we would take the supervisors out to dinner, or you take the adjusters out to dinner, and they would have that relationship. But as things have progressed, it's not those individual adjusters that are choosing their lawyers. It's the higher ups, the supervisors, that are having quote unquote panel counsel saying, okay, these three people in the state of Wyoming or in Montana or in Idaho, wherever, those are the people that can do our work. And adjusters send your work to these people. So there's not a lot of whining and dining. At some level there is, but for most firms, not so much.
Well, and going back to the whole balance thing, and I think where plaintiffs' attorneys get frustrated with defense attorneys sometimes is how long it takes them to evaluate, what hoops have to be jumped through in order to settle. But if as a young attorney that started out at a defense firm, there really wasn't an incentive from anyone, from the insurance side, from you as a senior associate to when you became a partner to the real partners, to hurry up and settle a case. Instead, it was let's work this case up. In other words, how can I even give advice to an insurance company to settle it if I haven't done what would be kind of the defense due diligence? So could you talk a little bit about why there's not an incentive in the system to quickly resolve cases?
If a law firm resolves cases early, that's work that they're just giving away, right? And there are firms, not my own firm, or our own firm, but that you have to go through and take every deposition and file every motion, and then you can think about settling the case. And that's what they're telling the insurance adjusters. Now, my experience is, with rare exception, the insurance companies wanted you to go out and aggressively pursue the case. And if you would come to them and say, hey, we can get this done for X amount, they wouldn't hear it. And they want you to aggressively pursue the case because they want to build their file. And they want to build their file both as the adjuster to justify their work and their existence and showing their supervisors that they're doing good work. But also that insurance company, they have internal audits to make sure that they're not just giving money out without justification. They have external audits, because some of these are public companies, to make sure that they're not just giving money out without doing due diligence. And another thing, a lot of these companies, they have reinsurance. So, they have insurance on their policies that are in litigation. And when they reach a certain amount, well, then the reinsurance kicks in to compensate them for the extra money that they're going to have to pay out. So there's a lot of sort of corporate push down with respect to paying claims. And the result is, you and I would talk about it, and we would think, and maybe I'm not a very good business person, but I would think, boy, if I can pay an extra $20,000 on a claim that I think it's worth, but I'm saving $80,000 on defense costs, well, I'm ahead of the game. For some reason, that's bad business. and the result of all this push down is the defense counsel are encouraged to go out and do all the work.
Well, and And you're exactly right. And we were. I remember I was involved in a tire case at our previous firm, and I would fly to Ohio, and I would do an hour and a half deposition, and getting from Wyoming to Ohio probably took 12 hours. Then I'd stay at a hotel, wake up the next day, do an hour and a half deposition, and come back. And there was never once a flinch that was bad, not the right thing to do. And of course, every hour on the airplane, I was billing. Every hour, preparation for the depot itself, and then every hour getting back. And that was, you've done it all over the country. I've done it all over the country. And that was actually looked at as good work. I wonder if COVID and the ability for depositions to take place on Zoom and stuff like that, if that's really hitting the bottom line of some of these insurance defense firms, that now there's been a model that's proven that you don't have to travel as much. You don't have to travel to go to court. You don't have to travel for depositions. You don't have to travel for mediation. Do you have any thoughts on that? And I know you weren't a defense person when COVID hit, but in the 19 years that you were, I could imagine firms would be taking a hit just on travel alone.
Oh, huge. And I've talked to some of my former colleagues about their thoughts on this, and they're stoked about it. And I would be too, because I'm not a great person sitting at my desk. I need to be moving and doing things. And so I made my money by traveling all over the country and unfortunately not being home very much. And now you don't have to do that. And that's just the bottom line for the insurance companies. And, from our side, prior to being really forced into doing a lot of video stuff, I think the predominant wisdom was, hey, you've got to be there in person, for the experts and for the defendants and things such as that. And, we've been thrust into this now this year of having to do defendants via video, or having to do big, complicated experts with a lot of exhibits by video. And it's pretty close to being there in person. I hate to say it, but it's pretty close to being there in person. And I think COVID is going to really change the game for insurance defense, and the travel is going to be cut down to very minimal, and it's going to be a lot of stuff via video, which for us is a good thing. I mean, we're going to be saving a whole lot of costs for our clients, and a whole lot of wear and tear on our bodies from not being on airplanes.
Well, yeah, and this is part of the interesting relationship that you have with the carrier. Again, you have with the partners. If we talk a little bit about the client, obviously the client's the insured, but there's a time where it seems confusing who the client is. When the insurance company is the one that's asking you for your notes, the insurance company is the one that's making you give litigation budgets. The insurance company is the one that pays your bills. Can you talk a little bit about that relationship with these two different parties, or this tripartite relationship between actual person paying to have insurance coverage, the insurer who provides the coverage, and you in your role as a defense counsel for all those years?
Yeah, and it's a tough relationship, and each state is a little bit different with respect to the duties owed in that tripartite relationship. Some states, there are more duties that are owed to the insurance company than other states. For the most part, very generally, all of your ethical obligations and your duties are owed to your client. You have some obligations, of course, to the insurance company. But it is a real struggle, as we kind of touched on earlier, where they're paying your bills, and you've got to make them happy, or happy enough to give you another case in the future, or to give you a lot of cases in the future. And if you're telling them what they don't want to hear all the time, they're less likely to give you cases in the future. And so if you're constantly telling them, hey, dummies, you need to pay money on this, and you're way too low on your valuation, well, they don't like to hear that. They don't like to hear it as a company, and the adjuster doesn't like to hear it because they've got to then go spend more time with their supervisor asking for more money. And guess what? They're not saying, supervisor, hey, I made a mistake and misvalued this. They're saying, hey, this attorney, this defense attorney, just worked this case up, and now tells me he's not going to go try the case because it's worth more, right? We got to settle the case. And so it's a tough relationship. In our firm, it was always the client was where you owe your duties. And, there were times that I would, you'd have to take that hard stance with the insurance company. And, for example, when you would have a case that got into an excess situation, I always, the first thing I did was call the insurance company and say, hey, this is an excess. I'm going to send you a letter that demands you settle this case on behalf of my client. And I'm going to get outside counsel, personal counsel, for your insured, my client, to do the same. And a lot of carriers understood this, and they knew that was part of your duties. But there were some, quite frankly, that would just get extraordinarily upset when they would get that letter from me saying, you have to settle this case. And they would call up screaming, and I got fired a couple of times for doing it because I did what in my view was the right thing for the client. But what they are accustomed to is defense counsel sort of towing the party line.
Well, when you're communicating with the insured, would you have these kind of frank conversations? I know there's a reason why you'd put it in writing to the insurance company, but could you actually have a conversation with the insured and say, look, there's some exposure here, and because of what's happened in this case, they may be able to come after your assets in excess if there were an excess judgment in this case? Would you call somebody up and go through that with them?
The client, you mean?
Yeah, the client.
Yeah. Oh, for sure. For sure. Because these people, for the most part, except for sometimes when you're representing a company, and they say it's an oil company and there's a big bad wreck or explosion, or if it was a physician, and even in those situations, they don't want to be bothered with the litigation. That's why they pay insurance. And so a lot of times when you're calling up your client and you're the lawyer and you're calling them up to say, hey, I'm doing this on your behalf and here are the real risks here, you're bothering them. And that's just human nature, right? They pay insurance, they want it to be resolved. But there are times when I would forward the settlement demand to the plaintiff or to the client, and they would call up saying, oh my God, are they coming after my house? Are they coming after my 401k, they would think? And you would have to walk them through, okay, here's their demand. I don't value the case this way. They want $2 million. I think the case, if it gets away from us, is an $800,000 case, but really it's a $400,000 case. And you'd have to walk them through that, but then always assure them, hey, if I ever think that your assets are at risk, I'm telling you, and we're going to and you're going to find personal counsel. I'm going to help you do that. And also I'm going to send a separate letter to the insurance company demanding they protect you. And so in that sense, yeah, people do get concerned, and there's a real value as a trial lawyer, in the right case, not in every case, in the right case, to be sending those letters saying, hey, your client, your insured, is at risk, and if you don't settle this case, I am going to come after them. Because you have to say that in order to be able to get to the excess, to get to break open the policy. So yeah, sometimes those were scary, hard conversations.
Well, and Jason, I think practically, as you know, one of the big teachings of Nick Rowley and running with the bulls is, of course, to say and let the client know, hey, you may need personal counsel here. But a lot of these cases, there's not a lot of insurance. People have the state minimums, or even if there is more insurance, they may not have the money to go get personal counsel. How do you walk somebody through potential exposure when they might not even have the wherewithal to hire a private counsel to review the case and the exposure?
Yeah. Well, I tell you what I did is almost 90% of the time, personal counsel was a buddy of mine that did plaintiff's work, and I'd say, hey, here's a letter. Put this on your letterhead if you don't mind, and send this on behalf of your new client. And they would do that, because it's helping real people, right? But you're right. If you have a situation of a lower limit case, or people who aren't sophisticated and have the financial ability to go get a lawyer, they're not going to go pay a lawyer a few $1,000s and they can't to take a peek into a case and write a good demand letter for them. They just can't.
I think one thing that folks will find interesting is this whole idea that you get fired from insurance companies when basically telling them they have a duty, and that duty is to provide coverage, and you're recommending that they provide that coverage. I know you had a case that you told me about previously that you did this letter, you end up getting a great judgment, and then you end up getting fired. Could you tell that story for the folks listening?
Sure, and it wasn't a judgment. It was just a settlement, but it was a case. It was a shoulder injury, and I think they only had $100,000 and of a policy, and so we're going through and trying to determine, hey, what's the extent of the shoulder injury? Is it a sprain? Is it something where they're going to go need surgical intervention for and have problems throughout their life? Because if it's just a sprain, maybe it's not a big deal, and it's certainly not worth $100,000. But if they need the surgical intervention and it is going to be something that's going to affect them, well, hell, it's going to break open the policy. And so we worked the case up, and I came to the conclusion that it is a real case, and it is something that is going to get past the policy. I want to say it was a long time ago, and I'm trying to remember back the values, but I want to say the carrier wanted to pay $40,000 on it, and that was their top dollar. And the plaintiff's lawyer, I think they wanted like 60 or 65. And so I walked in, and it was a case where it was a liability case, right? There was no defense. And so I would talk to the adjuster on the phone and say, hey, you're going to pay me more money to go try this case, and that's the cost of admission, only for the benefit of paying out at least, $25,000, $30,000 for the judgment, or on top of that, maybe $150,000 to $200,000 on a verdict. And they would say, we don't care. We're going to go forward and try the case. We don't care. And I said, okay, you can do that, but you need to send a letter indemnifying my client, your insurer, of an excess. And they said, we don't do that. I said, okay. So I wrote him a letter, and I detailed that in writing, because of course on the phone it doesn't matter because there's no record of it, right? So I detailed that, the cost of trying the case, and then the very real aspect of putting their insured at risk. I wrote that letter. They called me up. They said, okay, pay the 65 or whatever it was, which was a great settlement, quite frankly, for a defense settlement. And then they spent 30 minutes screaming at me and taking all my cases away.
I really appreciate Jason and Jakob, you providing some insight into the rest of us about how this all works behind the scenes, because as you said, it's so unknown, especially for a lot of our listeners that have never had, the only interactions I've had with the defense have been, one on one side, one on the other, and probably not that positive. So I really do appreciate this. And for everyone listening, if you are enjoying this episode, make sure you do stay tuned for part 3 of this interview, where we cover settlement opportunity letters, settlements, plus we actually answer your questions live. So make sure you do comment in with your questions, because we will be covering them from part 1 and part 2. Remember to like, comment, and subscribe on Apple Podcasts and Spotify to Settlement Nation.